Morning, everybody. Thank you for joining us today. My name is Charles Livingstone. I'm a partner in the Government Regulation and Competition team at Brodies. I have acted for a number of clients in relation to procurement matters, both contentious and non-contentious, and both on the public authority side and on the bidder/challenger side. And I'm joined today by Christine O'Neill QC, who is also a partner in our Government Regulation and Competition team. Christine's also the chairman of the firm, and as you can tell by the fact she's a QC, she's a solicitor advocate. Christine has appeared in a number of procurement litigation cases, most often, but not exclusively, in her previous role as first standing junior to the Scottish Government, and you'll hear about some of those cases in which Christine has been involved. Has been involved later in the session. So in terms of the overview of what we're covering today, I'm going to speak about some of the basics of procurement in Scotland. I'm going to keep that very high level because this is a session that's focused on procurement litigation and is directed at non-Scots lawyers. So just sort of a slight health warning. We are pitching it in a way that assumes a relatively high degree of knowledge of the substance of procurement law, and to some extent assumes some knowledge of litigation in jurisdictions outside Scotland in relation to procurement matters. So hopefully that's pitched at the right level for everyone that we have joining us today. But obviously, if there are any things that you'd like us to clarify, then do put those questions in the Q&A box. So after we've covered some of the basics, I'll move on to cover procurement litigation in Scotland, focusing on the key points to note if you have a client who comes to you with a problem in Scotland. So what the initial things that you need to know are, and in particular, flagging some of the differences with the public contracts regulations that apply elsewhere in the UK, as those from experience and also just in terms of common sense, those are the points that are most likely to have a risk of catching out people who are familiar with the process elsewhere, but not necessarily in Scotland. I'll then hand over to Christine to take you through some useful case law from the Scottish courts that may be useful to you when advising your clients and which may be underappreciated in other jurisdictions. And then we'll close with a brief discussion of potential future developments in relation to procurement in Scotland. So on to our first section, procurement in Scotland, the basics. So the most basic thing you need to know is that there are separate public contracts regulations in Scotland. So through the slides, those will be referred to as the PCSRs. Bit of a mouthful, so I'll just refer to the Scottish regulations when I'm speaking to you. They are distinct from the Public Contracts Regulations 2015, which are, as a very rough shorthand, we'll refer to as the RUK, Rest of UK regulations, and which again are noted throughout the slides as the PCRs. So the Scottish regulations will cover various bodies. Most commonly, you will see them relied on in relation to the Scottish Government and its non-departmental public bodies, etc., Scottish local authorities and NHS Scotland. And NHS Scotland you'll often see cited in case law as Common Services Agency. So if you ever see cases with, and there are a number of them with Common Services Agency in them, you'll know that's NHS Scotland. The regulations on which the authority is relying should be noted in the contract notices themselves. So certainly by the time we get to procurement litigation, there shouldn't be any particular doubt over the regulations on which the authority is relying and that you'll need to rely on for the purposes of a challenge. So you shouldn't be in too much doubt, if ever, about which set of regulations you're looking at. The substantive rules that are set out in the Scottish regulations are essentially the same. That will not come as a surprise. After all, the Scottish regs and the UK regs are all based on the EU directive, and there's only so much scope for deviation from the substance of those. The remedies in a challenge are the same. They are setting aside a decision or a step procedure court can order amendment of documents, can award damages to an agreed bidder, can, in the same sets of circumstances as elsewhere, make a declaration of ineffectiveness, and it can, by interim order, suspend either the procurement procedure itself or the implementation of decisions or actions by the authority. And the timings are also broadly the same. So you have the 10-day standstill period after contract award. You have 30 days for challenging, extendable up to 3 months, running from awareness of the grounds of challenge. And Christine will talk about how that's been applied in a few Scottish cases. One point to note is that unlike the provision PCR 92, there's no backstop, no potential extension of that 30 days by reference to the date when reasons for a decision were produced. So it is just 30 days. If your client knows that a decision is going to be made, the 30 days may run from that date, regardless of whether a formal notice has been issued. And similarly, there's a 6-month period for any cases claiming ineffectiveness. But I've just noted this. It's a very, very minor point, but it does just illustrate that there can be very subtle distinctions between the two sets of regulations. So in Scotland, ineffectiveness, the timing runs 6 months from the date of the contract was entered into, rather than, as the PCR say, 6 months beginning with the day after. So you may actually find that your 6-month period is 1 day shorter or longer, depending on which regulations you're looking at. I'm sure nobody would want to get themselves into the position where they were right up against or that hard up against a 6-month deadline, but it just illustrates that there are subtle differences. The other point that you need to be aware of that is very different in Scotland is that for contracts that are not covered by the, let's call them the OJU thresholds, even though that's not technically correct anymore, but I think everyone understands the term. For those below threshold contracts, there is a second tranche of contracts in Scotland that are subject to a different set of procurement rules, and those are set out in the Procurement Scotland Act 2014. They're broadly similar to the Scottish procurement regs, to the extent that they impose the same general duties on public authorities of transparency, equal treatment, etc. They require authorities to place contract and award notices on Public Contract Scotland, and they have the same exclusion and selection criteria in relation to bidders. There are lower thresholds, so you have this mid-tranche of contracts that are not subject to the Public Contract Scotland regulations, but are subject to this Act. For supply and services contracts, that's £50,000 value. For works, it's £2 million. And this Act applies to public authorities that have functions that are exercisable in Scotland that do not relate to reserved matters under the Scotland Act 1998. That's a webinar entirely in and of itself. Suffice to say that that's about the limits of devolution. So the Act here applies to what you might call devolved public authorities. You can have challenges under the 2014 Act, but so far none have been reported, so they won't be featuring in Christine's case law update. There are limited grounds for challenging. The general duties are a ground of challenge in the same way as they are under the regulations, and as with the regulations, much of the things you might want to challenge, you may be able to get within the boundaries of those general duties. You can also challenge due to a failure to publish contract notices or award notices, and failures to apply the various mandatory criteria on exclusion and selection, technical specifications. If an authority charges to participate in a tender, doesn't give reasons, or fails to comply with the obligation to give feedback. The procedure for a challenge is very similar to the procedure that I'll be speaking about in a moment in terms of the forum, pre-action requirements, time bar, etc. You also have the same remedies: interim suspension, set aside, amendment, damages, but the Act doesn't have the very bidder-friendly elements of the regulations. So there's no mandatory standstill period that obviously facilitates a challenge. There's no automatic suspension that similarly facilitates a challenge, and there's no possibility of ineffectiveness. So I think that absence of those bidder-friendly measures is possibly one of the reasons why we haven't seen any 2014 Act challenges so far. So we're not going to say any more about the Act other than just to flag to you that it is there. So if you have a client dealing with a procurement in Scotland, you don't necessarily need to limit yourself to asking the question, is this over the OJU thresholds? Okay, so moving on to litigation properly and covering just some of the key points to note and the differences with the PCRs. One big difference in Scotland is that you actually have a choice of courts. The PCRs require cases to be brought in the High Court. In Scotland, it can be the Court of Session or it can be the Sheriff Court. Most procurement cases are brought in the Court of Session. Most of those are brought in the commercial court within the Court of Session, which has its own sort of practice directions. The procedure is not particularly different, but the commercial court does add certain bolt-ons. You can also be confident that you will be likely to get a judge with procurement experience if you go through the commercial court, but it's not mandatory for procurement cases to go through that route. Alternatively, you can bring procurement cases in the Sheriff Court. We are only aware of 2 reported cases in the Sheriff Court. There may obviously have been unreported cases, there may have been threatened cases. The 2 that we're aware of, Farron's Construction against Glasgow City Council, which for obvious reasons took place in Glasgow Sheriff Court, which does have a commercial court within it. So if there was any Sheriff Court where you might take a procurement action, it would probably be Glasgow. And the other one is Duncan Mackay and Sons against Western Isles Council. That's the Gaelic translation of Western Isles Council, which I won't defile by attempting to pronounce. So that case was brought in Stornoway Sheriff Court. And there may be, that may be the type of case where a local sheriff may be more sympathetic to the bidder's case. If it's, for example, a significant local employer, they may be more sympathetic to the bidder's case than the Court of Session would be. So there are potentially going to be tactical considerations in deciding whether you go to the Court of Session or the Sheriff Court. Most of the cases that we, or all the cases we have brought have been in the Court of Session, and that would tend to be our default, but the Sheriff Court is there as a possibility. So in terms of commencing proceedings, the first really key point to note in terms of differences with the PCRs is that you need to not just get the proceedings into court, you need to then get them back from court and get them served on the authority in order to trigger automatic suspension of the authority's ability to award the contract, or indeed to defeat a time bar, whether that's 30 days or 6 months. So that is a significant difference with the PCRs, where all you need to do is have the claim form issued and then make the authority aware of it. You do actually need to serve it. And again, that may be another reason why you would go to a Sheriff Court, for example. If let's stick with Western Isles, if you were raising that case on the last day of your standstill period, you probably would not be able to get that into the Court of Session and then served in the Western Isles on the same day. If you did it very early in the Court of Session, you might get it to the council by close of business. But if that was looking in doubt, then what you would do is you would commence your proceedings in Stornoway Sheriff Court, and then you could arrange a local agent to serve on the council from there. One qualification to that consideration is that solicitors can accept service on behalf of their clients. So if there is a more remote public authority and they've already instructed solicitors with an Edinburgh office or a Glasgow office, then they may be instructed to accept service. Although again, that's not mandatory, and a client can decline to authorize their solicitor to accept service. So this is a very relevant timing consideration. In terms of how you commence proceedings, so if you're in the Court of Session, the initiating document is called a summons. In the Sheriff Court, it's called an initial writ. The differences between the two don't really matter for present purposes. What you need to know is that both of them require relatively full and detailed pleadings, so much more so than a claim form would tend to include. And usually you would instruct counsel or a solicitor advocate to prepare those pleadings at the outset. That therefore requires a fair amount of preparation and lead-in time before you're even going to be in a position to get your papers into court to then serve them. The other thing to note is that there is a requirement in the Scottish regulations to issue a letter before action. That is a statutory requirement to inform the authority of the grounds of challenge before commencing the action. So that is a competence issue. It's not a question of compatibility with practice directions, as it is in England and Wales, for example. It is competence. If you have not sent that letter, your action will be incompetent and the court will have no scope to waive your non-compliance. And Christine will cover a few cases in relation to that later on. So Scotland still has that obligation, which I know has come out of the PCRs, but you do still see it in other regimes as well. So it's still in the defence regulations, and it came up in, I think, 2019 in the Circle case against Secretary of State for Defence. So again, that's just another step that needs to be taken and ticked off before you can commence the proceedings. So if you're up against the end of a standstill, for example, you need to be building in time for this, and that's covered on the next slide. We strongly recommend that as a minimum, you would want to make sure that you're in the position, or that if you were instructing us, that we were in the position to instruct counsel or solicitor advocate by no later than first thing on the working day before service is required. That's probably the minimum that we would say counsel or solicitor advocate would be looking for in order to get the pleadings together in good enough time for it to then get into court and be served on the day it needs to be served. And it should be noted, and we've had to have difficult conversations with clients, and I think on one or two occasions with referring firms where we've been approached to get proceedings commenced in advance of the end of a standstill period, and we've just had to say it's too late. So we can still do it, but it's unlikely to be served before the end of the standstill. And if the instruction remains that it has to be done by the end of the standstill period, but counsel or the solicitor advocate believes that they have insufficient time to prepare that, then they may, in terms of their duties to the court, they may be obliged to decline to act if that instruction they think comes too late. So then working backwards a little bit further, in terms of getting papers and letter of instruction prepared to send to counsel or your solicitor advocate, we would say that we're likely to need at the very least half a day to pull all of that together. So that kind of equates to no later than 7.5 days through a 10-day standstill period. But even then, that would be the bare minimum, and obviously be more comfortable for all involved with more time than that. The fees are worth noting simply because they are significantly lower than they are or particularly can be in the High Court if you're seeking damages. Getting a summons signated, which is the step that allows you to then serve it, £128. So even though the work itself is probably more front-loaded than elsewhere, the court fees, I think, will probably more than offset the cost difference. So once you've got things served, it's probably worth just giving you a very high-level understanding of what the timings of the next stages are. This focused on the court session because, as I said, that's where we tend to do our procurement work. The pursuer, and that's the Scottish terminology for the plaintiff, for the applicant. The pursuer can seek interim orders at the outset of an action. So if they want to suspend a procurement procedure, then they can seek that at the outset. I've put a brief note there with the word caveats on it. For those of you who aren't familiar with caveats, they are a tool that allows a party to lodge a caveat with Scottish courts, with the court session, or with sheriff courts. That basically says to the court, if anybody seeks interim orders against me on an ex parte basis, the caveat will be triggered. I will be informed of that, and I will be given the opportunity to appear. So it basically removes almost entirely the risk of orders being given on an ex parte basis against you. That's not just for procurement purposes, that's for all purposes. So a general plug there for caveats if you have clients that do business in Scotland, maybe in their interest to lodge caveats. Leaving that aside, from service, there is a standard 21-day notice period. That's the standard length of time after service before the pursuer can lodge the summons for what we call calling. That essentially means returning it to the court and officially starting the process. It is possible to ask the court to shorten or lengthen the process, but 21 days is standard. The pursuer is not obliged to lodge the summons for calling at the end of that period. The only backstop against the pursuer is that the summons will expire if it's not called within a year and a day of service. If the defender wants to move things along, then they can protest the fact that it's not been called after 7 days after the notice period has expired. and the court will then make an order that requires the pursuer to lodge it for calling within usually 7 days. So there is a process by which the defender can shimmy things along. However, the summons calls, once it has called, the defender has 7 days to produce defences. From a procurement perspective, that obviously affects the timings of the next potential next stages of the process. But the key thing to note is that it is not necessary to wait until the summons has called, or indeed for the defender to have lodged defences before they can enrol a motion. A motion is a Scottish equivalent of an application. So if the authority wants to enrol a motion to lift the automatic suspension, they do not have to wait out that 21 days or 21 plus 7 days before the summons calls. They can do that on a before calling basis. And that is often how automatic suspension motions are dealt with. Okay, so the next slide, we're talking specifically about automatic suspension and the process for that. I've mentioned already that automatic suspension is triggered by service of the proceedings. So service suspends the authority's ability to enter into the contract framework in question. One difference with PCRs, particularly PCR 95, is that the action does not need to be in respect of the decision to make the award. So even if the action can be about the terms of the procurement documents, it can be commenced at the outset of the procurement process. The automatic suspension will be in place until that case is determined or the suspension is lifted. It doesn't particularly matter what aspect of the process it's about. The contract or framework to which it relates, the authority will not be able to enter into that contract or framework. The rest of the procedure can still proceed. They can continue right up to the point of awarding the contract. It's only the actual entering into the contract that's suspended. If the pursuer wants to stop that happening, stop the procedure in its tracks, then they have to go and actively seek an interim suspension order. The court can make an interim order to lift the automatic suspension. Unlike the PCRs, the authority can request that before the end of the standstill period. That would be very, very fast, because it would be fast on the part of the pursuer as well as fast on the part of the defender to get all that done before 10 days, but it is possible. If the automatic suspension is dealt with before defences have been lodged, which as I said is fairly common, you generally expect the authority to produce a written paper setting out its position and possibly lodge evidence, rather than just turning up at court with no notice either to the pursuer or to the court of what the authority's position is. The pursuer can also lodge additional information, but again, just emphasising the importance of front-loading the work in the summons. The expectation would be that the pursuer had set out its position and indeed had lodged the relevant documents in or with its summons. In terms of the next step, automatic suspension, the test for that, unlike the PCRs, it is not expressly the inverse test for whether a court would grant an interim interdict. Interdict is the Scottish equivalent of an injunction. In practice, the way the courts approach it is pretty similar to that. American cyanamide obviously features heavily in the PCR case law. It's not directly applicable in Scotland, and that's the case for procurement and for other actions. But certainly English case law will be persuasive, particularly if it's case law relating to the lifting of an automatic suspension. So what is the test in Scotland? Well, it's 92.2 of the Scottish regs. The court, and this applies to automatic suspension and other interim orders, the court may decide not to grant an interim order when the negative consequences are likely to outweigh the benefits. And it has to have regard to the considerations that decisions taken by a contracting authority should be reviewed effectively and as rapidly as possible. And the Inner House, our equivalent of the Court of Appeal, has expressed the same view. Consider the probable consequences of an interim order for all interests likely to be harmed, and consider the public interest. And then on the next slide, you'll see that the courts have added their sort of an additional gloss to that. So this is street lighting supplies against Scotland XL, 2014 case in the outer house of the court sessions. That's first instance, but by a judge who is now in the inner house. said it was common ground between the parties that in determining whether to grant an interim order should consider the factors referred to in regulation, what is now 92.2 that I just read. The strength of the pursuer's prima facie case, the balance of convenience, those two tests are the ones that you would usually look to for an interim order. And specifically, as in elsewhere in the UK, whether damages would be an adequate remedy for the pursuers. And he says this is now well-trodden ground, so there's no real doubt about what the test is that should be applied. The damages point, the relevance of that produces the same challenges as have come up in English cases. So how do you quantify loss of a chance? Ironically, the easier your damages would be to quantify, the more likely it is that the automatic suspension might be lifted. The flip side of that is the breach, well, connected to that, is the breach sufficiently serious in terms of the Nuclear Decommissioning Agency Frankovich decision? Is it sufficiently serious that it would sound in damages at all? So there are real tensions there in that damages point, but that is a very relevant part of the test. There's no practice of cross undertakings in Scotland or of putting conditions on the granting of interim orders. There's therefore no, and that when I say there's no practice of that, I mean generally there's no practice of that in relation to interim orders. Obtaining interdict or an injunction on a wrongful basis is a delict, that's our equivalent of tort. But it's not clear, and it's never been tested, whether and how the concept of wrongful interdict might apply to automatic suspension. So might there be a delict of wrongfully resisting an automatic suspension motion or a motion to lift the automatic suspension? Seems like a bit of a stretch. So the position there is less certain. But what it does mean is that an offer to give an undertaking and damages to the authority, if the authority suffers loss because the automatic suspension remains in place, that could, in theory, I've never seen it done, but certainly in theory, it could help sway a marginal decision and persuade a judge to leave the automatic suspension in place. So it's not a practice that we have, but it's not something I would rule out in the procurement context. It's probably fair to say that most cases don't proceed beyond the automatic suspension decision, partly because the court will tend to consider the strength of the pursuer's case in a fair amount of detail, so that if it thinks the case is weak, the pursuer will have been given a very clear steer not to continue. But even if the pursuer has a strong case, even if it has made out its case, as Christine will show in a couple of cases, the court may still say that on the balance of convenience and the basis of damages being adequate, that the automatic suspension should still be lifted. So Christine will go into that in a bit more detail. If we move on to the case law, I will hand over to Christine.
Thanks, Charles. Morning, everyone. So we've entitled this Useful Case Law, which we hope does in fact apply and is useful to you in avoiding obstacles that you might experience if you are raising or looking to raise proceedings in Scotland, but also some other cases that might be useful to you more generally on the substantive law. So Charles has already talked about pre-action correspondence. The relevant regulation in Scotland requires the bidder to inform the contracting authority of the breach or apprehended breach of the duty and of its intention to bring proceedings. So it's important that any pre-action correspondence deals both with the breaches and with the intention to bring proceedings. And there have been a number of cases where this has been litigated in the Scottish courts, and it can result in a case being dismissed altogether if you have failed in your pre-action correspondence obligations. So the first of the cases that I just want to mention is Shetland Line against the Scottish Ministers. There are a number of reported decisions from this case. It did proceed eventually to trial. It's a case where in fact the pursuer didn't lodge the summons for calling for more or just on a year. So they had raised proceedings, obtained automatic suspension. We managed to get the automatic suspension lifted. I was acting for the ministers, but the substantive dispute took quite a lot longer to resolve. And one of the preliminary issues that we raised was the nature of the pre-action correspondence and its timing. So what happened here was that the contracting authority, Transport Scotland, perhaps a little bit cutely, issued their contract, the standstill letters on a Friday afternoon, the Friday being before a bank holiday Monday, and leaving the bidders with a relatively short period of time to deal with a potential challenge. On the following Friday at 12:30, the pursuer's solicitors emailed Transport Scotland asking for an undertaking that they wouldn't enter into the contract without giving 7 days notice of their intention to do so, and that if they didn't give that undertaking, then they would take immediate court action. So that was at 12:30, and they asked for a response by 2:30. At 2:20, Transport Scotland said they wouldn't award the contract until at least another 7 days later, that they would provide a substantive response to the challenges, and they would have a meeting with the aggrieved bidder. And they asked for confirmation that proceedings wouldn't follow. And then at 3:30, the pursuer said that's not good enough, we are going to raise proceedings, and they served a summons at 5 o'clock that afternoon. Now, I complained on behalf of ministers about two things. I complained that they didn't give sufficient indication that they were going to bring proceedings, and I was told I was wrong about that, because the second email was unequivocal about that. And I also argued that there was insufficient time given to the ministers to deal with the problems that had been raised with them, less than 4 hours in which to do something about that. Now, ultimately, the court took the view that given the very short timescales concerned, and given the importance of securing an effective remedy for a pursuer in this sort of situation, that while they had some sympathy with Transport Scotland's position, the court took the view that sufficient notice had been given by the pursuer. That's in contrast to another case, Clinical Solutions, where the court had taken the view that by sending your pre-action correspondence after close of business and then serving a summons the same evening, that was not sufficient notice. But it does appear that even giving a few hours notice will be enough in terms of the timing of pre-action correspondence. That's different from failing to put together all of your grounds for review. So if we move on, there are a couple of cases that deal with this question. Hastings and Company was about the provision of insolvency practitioner services to the Scottish accountant in bankruptcy. And this was dealt with in the context of an application to lift the automatic suspension, where I was acting for the accountant in bankruptcy. And the pursuer here had brought around 6 or 7 different challenges in their action, but they had only referred to 3 or 4 of those challenges in their pre-action letter. And the court was clear that in respect of those that had not been dealt with properly in the pre-action letter, the pursuer was not entitled to pursue those in the subsequent litigation. Now, it may seem like a technical or unduly formalistic approach for the authority to take, but in this particular case, it was very helpful to be able to knock out nearly half of the challenges at that early stage, because it certainly affected the judge's view of the strength of the prima facie case for the purposes of lifting the automatic suspension. So it was helpful for the authority to be able to get rid of those at an early stage. A further case dealing with the same kind of issue is on the next slide, OLM Systems against Fife Council, and it's again just one that you can have in mind if you're thinking about what needs to go in a pre-action letter if you don't include your complaint, and this was a complaint about a failure to give adequate reasons, then that may be thrown out as a freestanding ground of complaint. The contrasting position is in Nationwide Girting Services, another case I'll talk about in a bit more detail. Here, where I objected again to new claims, I said, being added to the pursuer's case halfway through the litigation. In this case, the court said it wasn't a new claim. The overarching claim was about a direct award without competition. That had been the ground of complaint right from the beginning. But rather what they did here was they introduced new manifestations of the same ground of complaint by referring to other authorities from whom or other bodies from whom ministers had directly procured without competition, and adding new claims in terms of quantification. So it can depend on how you characterise a change that is made to the pleadings, but it is extremely important that if you know about potential grounds of complaint, you get them into your pre-action letter just as early as possible. If we move on then to time limits, and again Charles has mentioned this, and I'm sorry if we go back to Nationwide. So Nationwide was a case about the two terrible winters that Scotland and the rest of the UK had between 2009 and 2010, and then again 2010 to 2011. And if you remember, if you're old enough, there wasn't much gritting salt available in those winters because everybody needed it, and the Scottish ministers had, like many other authorities, procured salt from wherever they could and from whoever they could as quickly as they could during those winters. Nationwide came to be aware of that and eventually raised an action for damages on the grounds that direct procurement was not justified under the emergency provisions of the regulations. Here, they raised their action on the 28th of August 2012. The question was whether they had any relevant knowledge before the 28th of May 2012, if you work back 3 months. And we made various arguments again that Nationwide ought to have brought their proceedings sooner because they could have put together from a range of sources enough information to demonstrate that Transport Scotland had procured this salt and clearly had procured it without a competition because there was no ODU notice or contract award notice published in relation to these contracts. We relied on direct communications between NGS's agent and Transport Scotland. We relied on material that was in the public domain, including official and unofficial reports that had been published in 2010 that made clear that these procurements had taken place. And we also relied on what the pursuer themselves talked about as being a tip-off by one of their customers in April 2012. The court declined to hold that the claim was time barred, and one of the reasons I think that they did was that they were unhappy about the failure, as they saw it, by Transport Scotland properly to respond to FOI requests from Nationwide gritting. And I think there was a suggestion in the court's mind that the client had not been entirely candid in dealing with the FOI request. They had sent the FOI response on the 30th of May 2012, and the court took the view that the relevant time limit ran from there. Relevant factors in this particular case, which led the court to that conclusion, was that there had been no business relationship between NGS and Transport Scotland, so there was no underlying information that NGS would have about the way Transport Scotland was dealing with things. A bidder or a potential bidder isn't to assume that there has been a breach of the regulations, so they were entitled to wait for relevant material that allowed them to conclude that they did have a case. And of course, there had been no contract award notice in the official journal. If we just move on, then other cases that you might just want to have a look at in terms of when you know about a breach: Johnson & Johnson against Greater Glasgow Health Board, and AC White and Company against Renfrewshire Council. Johnson & Johnson is pretty straightforward. The court took the view that if your standstill letter is not sufficient to give rise to a legitimate concern on the part of the bidder that something has gone wrong, then they're not to be penalised for not guessing that something has gone wrong. AC White is quite interesting because in that case the aggrieved bidder had actually raised an action at an earlier stage. It had been dismissed for failure to comply with the pre-action letter requirement. They came along quite a little bit later and raised a fresh action, and the court took a sympathetic approach to allowing them to do so because the council had produced fresh material in the meantime, and the court took the view that the relevant time limit ran from the production of that material. I think that case I wouldn't regard as being one to rely on too heavily. The court dismissed the challenge on the substance, and you get the impression that it took a generous approach to the time limit and knowledge of the breach, mostly as a sop to the pursuer and to allow it to deal with the substance rather than taking a very strict view of the time limits. So if we move on, this is a case which I mentioned because there's very little reported case law in the UK generally on the issue of abnormally low bids, and I think it's quite a helpful case in terms of the wider principles on abnormally low bids. There's nothing peculiarly Scottish about it. Amy against the Scottish ministers. Again, this was dealt with in the context of an application to lift the automatic suspension. It was about roads maintenance contracts being awarded by Transport Scotland. And again, I acted for the Scottish ministers in this case. The photograph is intended to reflect on the fact that we had quite a lot of debate in the case about what it cost or what it might cost, for example, to paint a metre of white line versus a metre of yellow line, and how much it might cost to remove a dead fox, this one being very much alive, but to remove a dead fox from the side of the road. Now, the issue arose because the way that Transport Scotland dealt with its pricing of these contracts was to ask bidders to complete pretty complex and extensive spreadsheets, identifying a price per task, both for core operations and ancillary operations. And the minimum price specified in the tender documentation for any given task was a penny, so that there would be no column or row in the spreadsheet that had a zero. But on the face of it, bidders were entitled to bid a penny for a particular task or a particular set of tasks. Now, the authority, Transport Scotland, had estimated the value of this contract over 5 years as being around £137 million. Amy's bid came in at about £27 million when you added up all of the costs that they had entered into the spreadsheet. They had chosen, for example, for the core operations to price 84 of the 88 core operations in the tender at a penny, and they had priced 64% of the other items in the bid at a penny. Now, at one level, I have a degree of sympathy for Amy here, because the way that this spreadsheet was set up, they were entitled on the face of it to bid a penny. And I think many bidders in a similar situation will take a view on, and I use the word advisedly, gaming a pricing methodology in order to get a competitive advantage. And that's what Amy did. They were very open about the fact that they had priced in a way that they wanted to be commercially competitive and in a way that they thought would deliver this contract for them. Transport Scotland took the view that this at least triggered their obligation under the regulations to investigate what was on the face of it, an abnormally low bid. And Lord Hodge dealt with this, if we can move on to the next slide, by reference to the obligation under what was then Regulation 36 of the Scottish regulations. If an offer for a public contract is abnormally low, the contracting authority may reject the offer, but only if it follows the procedure specified in the regs. So it must request an explanation. It must then have regard to the explanation or evidence that's provided to it. And then it must verify the offer or parts of the offer that it judges to be abnormally low with the economic operator. And Lord Hodge took the view that in this case, the ministers had dealt with matters as they ought to have under the regulation. And if we move on, what he concluded was that the ministers had a difficulty here because many of the rates were artificial and had been manipulated to reduce the overall cost. And that in relation to what ministers had done to verify the bid, the court had a limited jurisdiction to review the process. So he took the view that there was no basis on which Amy could challenge the minister's conclusion that the offer carried unacceptable risks for ministers, and was neither economically viable or sustainable. And in terms of unacceptable risks, one of the concerns that Transport Scotland had was that because items were priced at a penny, the maximum amount that they would be able to withhold under the contract for non-performance of those items was a penny, and that was risky from an operational perspective. But they were also worried that the prices were simply too low to be viable or sustainable for the company offering the service. So ultimately, the court here didn't make a final determination, but for the purposes of lifting the automatic suspension, was satisfied that Amy's complaint here was a weak one. It's been cited in Northern Ireland in a case where the court was not satisfied that the authority had properly dealt with the question of the abnormally low offer, but I think it's the only other case in the UK that deals with abnormally low bids. And then if we move on to emergency direct awards, this is a quiz to just check if you're still listening. So the Scottish Transport Authority, Transport Scotland, has now a practice of naming its gritting lorries, a practice which has been described by the press in Scotland as hilarious. I'm not quite sure it's hilarious, but there is a prize, a yet to be determined prize, for the first person who can identify which of the following is not a name of a Transport Scotland gritter currently in operation. We have Gritty Gritty Bang Bang, we have Chilly Conley, we have Spready Mercury, and we have Sir Salter Scott. So if you've got nothing else from this seminar, please do tell us which one is not a gritter. But back to the law, as I've mentioned, nationwide gritting was about an emergency direct award of contracts for the procurement of salt over 2 winters. And it's the only case I'm aware of in which the emergency derogation in the directive and in the regulations has been litigated in the UK and litigated in detail in the UK. So the outcome of this case, if we move on to the next slide, was that the court took the view that there had been a genuine emergency in the first winter, a genuine emergency which justified the use of the emergency derogation. It had not been foreseeable that there would be such a crisis, both in terms of the weather, but also in terms of the availability of salt. Having said that, the court took the view that by the time you get to the next winter, where Transport Scotland had effectively adopted the same process of buying from those, or some of those that it had bought from in winter 1, the court took the view that by then the process ought to have been regularised, and they ought to have had a better procurement process in place. However, the ministers still won. Because they won on causation. The pursuer here was unable to prove to the court's satisfaction that it would have been in a position to supply grit in that particular winter. It was a new company, and therefore no damages were payable, notwithstanding the breach of the regulations. There was, of course, just the other week, the decision of the High Court in England in the Good Law Project against the Secretary of State for Health and Social Care about the way that contracts for PPE have been dealt with. I don't think there was any argument in that case that there hadn't been an emergency, or that the emergency derogation wouldn't have been fulfilled. The focus there was the failure to publish contract award notices after the event. If we move on, conscious that we are rapidly running out of time, we do have a case in Scotland, and I think certainly the first in the UK, the only reported case in Scotland of an ineffectiveness order being made, where the contract was awarded to a contracting body that was not, in fact, a contractor under the relevant framework. I've included a quotation from Lord Tyre. We'll send these slides afterwards. If you can work out what he means, you're doing a better job than me. And if we move on to automatic suspension, Charles has already talked about the general principles around automatic suspension. The courts in Scotland have generally been very, very supportive of authorities looking to lift the automatic suspension. and I was unaware of any case in which they had failed to lift the automatic suspension until I appeared for Aberdeenshire Council in Scott and Company against Aberdeenshire Council. And here the court left the automatic suspension in place, but only because there was going to be a substantive hearing in the next 2 weeks. So again, very, very, very sympathetic generally to contracting authorities. If you're the winning bidder, and a contract that there has been an automatic suspension, then in our view, it pays to be involved in the automatic suspension hearing. You're entitled to be involved, and it's often very helpful to hear from the winning bidder on how an automatic suspension will affect their preparations for mobilisation and how it might harm them. So we've appeared in a number of cases for winning bidders to add their voice in automatic suspension hearings. I think, Charles, you're going to very rapidly look to the future.
Yep. Thanks, Christine. So yes, looking to the future, and the key message, I think, is increased divergence. So procurement is not a subject that's reserved to Westminster under the Scotland Act 1998. Again, won't get into the detail of that. The Scottish Parliament and Scottish Government were constrained in what they could do in the area by EU law, but obviously that no longer applies. So they do now have a much freer hand than they did pre-Brexit. There are intergovernmental discussions across the UK various authorities on post-Brexit, what are called common frameworks, which they will seek to agree to minimise intra-UK barriers to trade. Public procurement is in one of the lower risk categories, so it's been identified as requiring only a non-legislative framework, so no statutory controls on what authorities can do. But the main thing to note in this respect is that the Scottish Government has a policy of what it calls keeping pace with EU law, at least in those areas where it would be within devolved competence to do so. An act recently passed by the Scottish Parliament gives the Scottish Government the power to keep pace with EU law by essentially incorporating developments in EU law into Scots law by way of secondary legislation, no acts of the Scottish Parliament required. And there's no obvious reason why the Scottish Government wouldn't extend that policy to any changes in procurement law at EU level. EU law no longer applies. There will be some common constraints by reference to the GPA and the Trade and Cooperation Agreement. They'll set some minimum standards, but I think the main point is that the UK government's Green Paper, if that is adopted, seems very unlikely to be agreed as the basis for a common framework. So if that is adopted, I would expect Scotland to not follow suit. And so you would be looking at much more divergence on substantive issues than exist at the moment. So for the key points, just before we do that, last call for contributions to Christine's Gritter quiz. And for questions, we've got a couple, but maybe able to fit in a couple more. So the key points, that there are substantive differences, there are currently only limited substantive differences between the Scottish regs and the RUK regs, but there is scope for further divergence going forward, so do keep that in mind. What is very different, I hope you've taken from this session, is that the litigation process is very different. The pleadings are front-loaded. There's the mandatory pre-action correspondence. You have to get proceedings served, not just lodged. So please do build in enough time to get through those steps if a client comes to you with an issue in Scotland. We're happy to be teed up early, if you'd like to instruct us, even if it remains to be confirmed whether the client wants to press the button on anything or indeed spend any money on Scottish lawyers. I would just say that those timing considerations, we don't flag them purely for our own benefit to make things more comfortable and give us more time if instructed. Authorities obviously have the same considerations when they are considering how credible a threat of action is. In order to make a credible threat of taking protective proceedings, for example, if a standstill period is not extended, the earlier you make that threat, the more credible it's going to be. So if you're looking to secure a negotiated outcome, which we certainly have experience of doing, if you're looking to secure that negotiated outcome, then the earlier you can start to push that threat of taking protective proceedings within the standstill period, the better. Because if you're only making that for the first time on day 10, authorities will know you do not have time to get into court before standstill expires. As I hope you've certainly taken from Christine's section, Scottish case law may well come in handy. So do keep it in mind. We've got some questions. I will pick up one very quickly. So are there any particular differences relating to the utilities contracts regulations that differ from public contracts? Scotland does have its own utilities contracts regs as well, and indeed concessions. There are no substantive differences between them for the purposes of what we've been discussing. So the service requirements, the timings, the need for pre-action correspondence, those are the same.
I'll take the next two.
Yep.
So there are two questions that are of a similar kind of theme. How long does it take to get to trial in the Court of Session, and is expedition possible? And then in Northern Ireland, challenging bidders will try to prevent an automatic suspension being lifted by pushing for an accelerated full hearing. And is that happening in Scotland too? So the answer is yes. I would say that being able to demonstrate that you can get to a substantive hearing quickly is going to be one of the strongest grounds for keeping the automatic suspension in place. I should also say that a substantive hearing in Scotland need not involve a full trial with evidence. Quite a lot of procurement cases are dealt with essentially on the pleadings and written material rather than witness evidence. And if there is a point that can be taken without witnesses, then you can probably get to trial quite quickly. I would also say that our experience during COVID, particularly with virtual hearings and remote litigation, is that the courts, bizarrely enough, and certainly the Court of Session, is working faster than it would do under normal circumstances, and we are getting hearings really quite quickly. Charles, I don't know if you want to take the last one.
Yeah, so we have a question of why would the Scottish Government not follow the UK Green Paper approach in principle? I think in principle is the right term to use there. I think in sorry.
I was just saying careful. Watch the
yeah, yeah. I mean the Scottish Government is obviously an SNP government. Putting it very neutrally, it will feel no particular compunction to take a joined up approach across the UK if it does not think it's in Scotland's interests. And what I didn't say expressly in relation to the keeping pace power, which no doubt many of you will have worked out, at least part of the thinking behind that keeping pace power is to try and keep Scotland in as strong a position as possible for an application for EU membership. In the event that the SNP and Scottish Government policy of Scottish independence was to be realised. So I think anything that takes the position in Scotland, that takes Scots law away from compliance with the acquis, things will happen that go in that direction, but the Scottish Government's default will be to avoid doing that. And then Christine, one more question just to close. One more question
just to finish us off, which is about the types of disclosure processes that exist under Scots law or these procedures. And essentially, there is not the kind of, or there does not tend to be the kind of proactive disclosure by public authorities in Scottish litigation that exists in other parts of the UK. But it is possible using an application for disclosure. We would call it an application for commission and diligence with a specification of documents. You can recover, and you can recover quite early, very, very comprehensive records of procurement exercises. So it's a more complicated answer than that, but we're not going to keep you past 12 o'clock to answer it. I'm happy to pick it up separately if that would be helpful. On gritters, I'm afraid I was a bit devious. All of the gritter names that I gave you were real gritters, but Emily Heard gets the prize, whatever that turns out to be, for playing the game, which no one else did. So thank you very much, Emily, for humouring me. Charles, do you want to finish?
Yeah, I'll just finish just by reverting to our contact slide. I hope you found today useful. Thank you for your time. If you do have any issues, then drop us a line, pick up the phone, again, very happy to just sort of have an informal chat to see if there's an issue that might be worth looking at in more detail. If you do have clients that need assistance, then we are very much here for you. So thanks again for your time.
Thank you.
Bye.
Bye-bye.